Hey folks, good afternoon. My name is Greg McLawsen. I am the Affidavit of Support lawyer. I help green card holders enforce rights under the USCIS Form I-864, mostly in federal court, and that is what I'm getting ready for today, heading into federal court. And wanted to talk about that because I love going to court. It's actually one of my favorite parts of my job. I love the ceremony of it. I like the formality of it. And I like talking to judges about the affidavit of support because in a lot of my cases, they've never seen a claim of this nature before. So it's often very interesting to go into court and argue these issues to the judge. However, I know that a lot of my clients, almost all of my clients, feel differently about going to court. A lot of my clients are either going through a divorce or they've just been through a divorce. And like most people, they don't relish the idea of going back into a courtroom. I understand that. So, when they are considering the possibility of enforcing rights under the affidavit of support, one of the first questions is often, how often am I going to have to go to court for this case? Now, federal court is different from divorce proceedings in a lot of ways. But one of the important kind of procedural flavors of federal court is that a lot of the decisions that judges make in a case are made on the strength of written submissions, which means that the lawyers present whatever argument and evidence they want to. And a lot of times that will go to a judge without having the parties show up and actually argue a case to the judge. Big picture. Now, I'm making a generalization here. In most of my cases, my client never sees the inside of a courtroom. So, on average, the number of appearances that one of my clients has to make in one of these cases is about zero. Most of my clients never have to show up to court in one of these cases. Now, let me qualify that with the important statement that if you bring a claim in federal court as the plaintiff, that means you are the person enforcing rights under the affidavit of support. This is your lawsuit. You are the one bringing the case. It is ultimately your responsibility. The lawyer in the case is there to help you and to present your case, but it is your case. So that means if the judge wants to hear from you for any reason in your case, you better believe you are going to show up to court. So the general statement that I'm making that most of my clients don't have to go to court is because as a procedural matter, it's typically not required. But you just need to be ready for the fact that if you are bringing a federal claim, this is a big deal, and you absolutely need to be ready to participate in your own case, and if needed, to go to court. But let's talk about how things generally go. First of all, like I had mentioned, federal court typically makes decisions on the basis of written submissions by the attorneys. Even in situations where the federal judge does want to hear from the attorneys, this is really common, for example, early in the case when the judge is trying to figure out what kind of a lawsuit is this? How complicated is it? How much work is it going to take for the parties to exchange information in the case? That's called the discovery process. A lot of times, the judge is going to have the parties appear for something called a case management conference, or a CMC for short. But that is a procedural hearing that is handled by the attorneys. Excuse me. So if this is your case, you're welcome to show up. But in terms of what the judge's expectations are, almost always those sort of procedural hearings are handled exclusively by the attorneys. The only time that you would for sure need to show up for court is if a case proceeds all the way to trial. That is extremely uncommon, not impossible. It's not that it never happens, but that's extremely uncommon in these cases. for the reason that we can usually get them resolved either through negotiation or through something called a motion for summary judgment. And all of that happens before a case goes to trial. The idea of a summary judgment motion, I don't want to get into this too much, but it's basically a way of going to the judge and saying, Your Honor, there's no real argument about the facts of the case. In this affidavit of support case, we know that my client came to the United States. We know that the defendant signed the affidavit of support. How do we know this? Because we have the official records from USCIS. And so the only other issue that we need to have any sort of argument about is my client's income. But a lot of times that's not really at question either. If somebody is unemployed, there's not necessarily going to be any factual issue deserving of a trial to prove that. So in a lot of these cases, it ultimately gets resolved before there's any reason to have a trial. Now, the other, leaving aside the possibility of a trial, the other time that a client's participation can be absolutely mandatory is at a mediation or a settlement conference. Now, you may have already been through a mediation in your divorce, and a lot of times, if you are a lot like a lot of my clients, you've had a terrible experience with that. Oftentimes, feelings are running very high in a divorce process. There are fantastic family law mediators out there and some really bad ones. So sometimes my clients have had the experience, especially if they were representing themselves, of going to a family law mediation and feeling like they were not being heard, feeling like they were being railroaded through the process. In federal court, I have had, almost without exception, really, really positive experiences in mediation. And mediation is really just a fancy word for getting the parties to sit down at the table and to see if they can work through a negotiated resolution to a case. The mediator, who is usually a federal court judge, has no authority to decide issues in the case. So we aren't arguing to the judge about how he or she should decide the case. The judge is there in the mediation context simply to facilitate a conversation between the parties. As a statistical matter, the vast majority of these cases that go to mediation ultimately get resolved there. And you can't do this. I can't do it without my client present. The judge won't even allow mediation to proceed because the whole idea of mediation is to have all of the parties in the room and to see if they can cooperatively reach a resolution of the case. You can't do that unless people are there with the ability in real time to resolve a case, because the goal in mediation is not to get close to settlement. It is to get absolutely all the way there and to leave the mediation session with an enforceable settlement agreement that fully resolves the case. But in terms of the client's appearance at these, historically, these were done in conference rooms at federal courthouses. So you'd show up actually at the courthouse, you'd go to a jury room or go to a room in the judge's chambers and sit down either with the other party in the same room or with them next door. Since the pandemic, almost all, not every single one, but almost all mediations these days are conducted via Zoom. That is typically done, even if I tell the court we would rather show up because we think it's going to be more effective. Usually judges, for their own convenience and the convenience of just getting things facilitated and moving forward, will more often than not require these mediations be done by Zoom. So that means that in the course of the life cycle of your affidavit of support case, the time that you are most likely to need to be in court, you don't actually have to go there. It's more likely that the judge is going to actually require you to appear by Zoom and say, we don't want you to show up in person. We think it's easier to handle these by Zoom. Now, trial is different. If a case goes to trial, that's something you absolutely do need to appear for in person, except in really unusual situations. But again, to take a step back, to the extent that any of my clients in these affidavit of support cases end up going to court, By far, we can use real grammar here. By far, the most common reason is mediation. And when that happens, it is most often by Zoom. The other thing to say about mediation is that it is not an adversarial proceeding. So you aren't taking the witness stand. The other attorney is not asking my client questions. It's a much more relaxed environment. The client is sitting there digitally next to me, and we are talking to the settlement judge. It's a very informal, typically casual conversation. So it doesn't have any of those high pressure aspects of court proceedings that my clients are understandably not wanting to get into. They also, in the mediation context, do not have to talk to the other side. So obviously, we are communicating with the other side because the entire purpose of the mediation process is to try to get a deal done. But this is not a situation where my client is sitting on the stand getting grilled by the defense attorney. That doesn't happen. The opposing party, so the ex-husband or ex-wife, can't ask my client direct questions. So there's no reason to have the sort of anxiety that you might feel about a court proceeding, because that just doesn't apply in the mediation context. A lot of times, my clients are a little bit stressed about mediation because, of course, they want to get the case done and they want to move on with their life. But in terms of how the actual hearing goes down, it's not stressful in any of the ways that you might be familiar with court hearings being stressful. For the same reason, they're not quite as exciting for lawyers, because we don't get to present our arguments to the judge in the ways that can be fun in a courtroom proceeding. It has none of that sort of adversarial nature. In fact, the entire purpose of mediation is that it's intended to be a collaborative process where everybody sits down to the table and tries to get a deal done if they possibly can. So, big picture, when it comes to these federal cases to enforce the affidavit of support, most of my clients never have to see the inside of the courtroom. To the extent they have any sort of appearance in these cases, it is typically limited to a mediation or a settlement conference. And that, again, doesn't have any of the stressful components of an actual court hearing. In the rare case that a client has to appear in a court proceeding, it would be for trial. But as a statistical matter, it is far more likely that the case will get resolved either in mediation or through that summary judgment process that I mentioned, long before the case is ready to go to trial. You have to be prepared. You have to be prepared to participate in your case because it is your case. But in terms of actual statistical likelihood, it is more likely than not that mediation is the only time you're actually going to be appearing in an affidavit of support case. Just in terms of answering a question that came in, because I am live. Somebody's asking who decides if a case goes to mediation. That's a great question. In some jurisdictions, the court will actually order the parties to go to mediation. In other situations, the parties have to agree to go to mediation. But in either situation, no party in a mediation ever has a responsibility to enter into a settlement if they don't want to. So at the end of the day, regardless of whether a judge tells you that you got to go to mediation, or if you make that decision yourself, you as the client always have authority to decide whether or not you are resolving your case. You always have the option to step back from any sort of offer that's on the table and say, no, I prefer to take my case to the judge, which is a different way of saying that the settlement offers that you would be inclined to accept, the agreements that my clients want to pursue, are the options that they think make more sense than going to court. Because a lot of times in mediation, you can achieve a result, especially in terms of how quickly you get paid, that's going to be better than going to court. And by the way, it is possible to reach settlement agreements that are better for both parties. I'll not get into my full spiel on mediation and alternative dispute resolution because I have a bunch of other videos on that. But oftentimes, a settlement agreement is better for my client who's enforcing the affidavit of support because they get money and they get paid quickly. But it's also better for the defendant because the defendant gets a known amount of liability. They know what they're going to have to pay, and they avoid all of the expense of going to court, which, by the way, is going to be their responsibility if mediation blows up. So even though my clients don't always care if the settlement is good or not for the other side, as a practical matter, it can really be a win-win for all involved because it's good for the person enforcing the affidavit, and it's actually less expensive for the defense to settle versus fight. That's court appearances in a nutshell. If you have other questions about enforcing the affidavit of support or would like a confidential case assessment, feel free to contact us at soundimmigration.com. I'll put a link in the comments. If you have other questions about enforcing the affidavit of support, I do these videos all the time. Happy to answer questions about affidavit of support enforcement. Take care, everybody. And now I am off to court. Wish me luck.